have you ever thought about what's really lurking in the fine print of your property deeds? I mean, besides the usual stuff. Well, imagine finding out you've inherited a medieval curse, one that's going to cost you nearly £1 million. Seriously. Today, we're going to dig into this absolutely bizarre, centuries-old law that came back to haunt one family in modern Britain. And it might just make you wonder what's hiding in your paperwork.
So let's head over to Warwickshire in England. And I want you to meet Andrew and Gail Wallbank. They own this place called Glebe Farm. And really, their life was the picture of rural English tranquility. You know the vibe. They were farmers, just living and working on their own land, paying their taxes, minding their business. But what they didn't know was that hidden deep in the ancient deeds of their beautiful farm was a financial time bomb. And it had been ticking away silently for centuries.
And then, well, one day that bomb went off. They get this bill in the mail. And it's not for their mortgage, it's not for a new tractor or anything like that. Nope, it was a bill for repairs to the local parish church, a church they didn't even own. And the amount? Get this, almost £1 million. Just unbelievable, right? I mean, how is that even possible? How can a private landowner be forced to pay for the upkeep of a church they have absolutely nothing to do with? It sounds like something straight out of a historical novel, not something that could happen in the 21st century. And that's the very question that would push the Wallbanks into a legal battle that went all the way to the top. Okay, so to figure this out, we can't just look at modern property law. That's not going to help. We have to rewind the clock, and I mean way back, by about 800 years. Yeah, the answer to this whole mess lies deep in England's medieval past. So here's how it worked back in the day. Originally, the local priest, the rector, was the one responsible for fixing up the church chancel. Simple enough. But then, you get to the 1530s, and along comes King Henry VIII, the guy with all the wives. His big break with the Catholic Church completely changed who owned what in England. He dissolved the monasteries and started selling off or giving away huge chunks of church land to private citizens. But, and this is the kicker, there was a catch. That responsibility to repair the church, it went with the land. It was basically baked into the deeds, like a legal chain passed from owner to owner, century after century, until, you guessed it, it landed right on the Wallbanks' doorstep in 2003. This whole thing actually has a name. It's called chancel repair liability. And it's this weird obligation that's not attached to a person, but to the land itself. So if you bought a piece of property that centuries ago belonged to a medieval church, you could unknowingly inherit this duty. Most people had totally forgotten it even existed, but legally, oh, it was still there. It's like a ghost lurking in the property records. It's just a perfect and kind of terrifying example of how ancient laws can have very real and very, very expensive consequences today. All right, so faced with a bill that would have meant total financial ruin, the Wallbanks did what anyone would do. They decided to fight. There was no way they were just going to accept that this ancient law could still hold up in the modern world. And that refusal, it sparked a huge modern-day legal showdown. Okay, so let's break down the arguments. On one side, you have the Wallbanks. They're saying, look, this is basically an unfair, discriminatory tax. It violates our human rights. We had no idea this even existed when we bought the farm. And you can see their point, right? But then, on the other side, you've got the Church Council, and their argument was pretty straightforward. They said, this isn't a tax. It's a property obligation, like a right-of-way. It's been legally valid for centuries, and when you bought the land, you bought the responsibility that came with it, whether you knew about it or not. And you have to understand, this wasn't just some minor disagreement. The stakes here were absolutely massive, not just for the Wallbanks, but for potentially thousands of other homeowners all across the country who might be sitting on the exact same legal time bomb without even knowing it. The case bounced all the way up through the court system until it landed at the very top, the House of Lords, which was the UK's Supreme Court at the time. So you can imagine the entire legal world was watching. This was the big question. Would the court side with a modern family and their human rights, or would it uphold a law that was almost 1,000 years old? The decision, whatever it was going to set a huge precedent for property owners everywhere. And then the verdict came down, and this is a direct quote from one of the law lords. Just listen to the wording here. He says, the landowner's chancel repair obligation is an incident of his land ownership. The obligation is burdensome. It may be crushingly so. Think about that. The court is openly admitting how devastating this is, crushingly so. But then comes the hammer blow. But the nature of the obligation is plain. And that was it.
The ancient law won. The House of Lords ruled against the wall banks. They found that, yep, chancel repair liability was a valid, enforceable property right. And because it was an obligation tied to the land itself, not a tax from the state, their human rights arguments just didn't hold up in the same way. The medieval ghost was real, and the wall banks were on the hook for the full amount. So what happened next? Well, the fallout from this was huge. This case was a massive wake-up call. It confirmed that this totally obscure law was still alive and kicking, and it sent absolute shockwaves through the property market. People were scrambling to find out if their own homes were affected. Now, the government did eventually step in and change the law. They said that these liabilities had to be officially registered on property titles by 2013 to be easily enforceable. So while that did offer some protection for new buyers, it didn't just magically erase the ghost for everyone whose liability was already on the books.
And that really brings us right back to the beginning. The Wallbank case is just this powerful, crazy reminder that sometimes the past isn't nearly as far away as we think it is, which really makes you wonder what kind of legal ghost could be hiding in your property deeds.